cordial welcome to our distinguished gathering. On behalf of our institution, I am delighted to welcome our esteemed chief guest, respected principals, and distinguished faculty members from various institutions to the fifth day of our faculty development program. I also extend a warm welcome to Shri M.R. Lakshmi Manohar Sir, Chairman, Governing Council VCL, to the session. Today's program features a lecture by Shri S. Shankarappa. Today's program features a lecture by Shri S. Shankarappa, a distinguished senior advocate and vice president of the AILU National Committee, on the significant topic of overhaul of Cr.P.C. 1973 with the Bharatiya Nagarika Suraksha Sanhitha 2023. We appreciate your presence and anticipate a productive and insightful discussion. Before we commence, I would like to inform you that due to unforeseen circumstances, our principal will be joining us later in the session. In the meantime, I am honored to extend a warm welcome to our distinguished chief guest on behalf of Janta Education Society's Vivekananda College of Law and privileged to present his brief profile. With a remarkable career spanning over 4 decades, Shri S. Shankarappa has established himself as a leading light in the legal world. His vast experience, expertise, and passion for justice have made him an eminent personality in the Indian legal fraternity. Born in 1952, Shankarappa completed his high school education at Chintamani Government High School and went on to pursue his graduation at Government College, Kolar. After working in a private company, he joined VB Puram Law College, Bengaluru to pursue his LLB and was enrolled as an advocate in 1981. Shankarappa began his legal career under the guidance of late Sri P.S. Devdas in Bangalore and has since appeared in numerous criminal trials across India, from Kashmir to Kanyakumari, and in various states including Andhra Pradesh, Tamil Nadu, Karnataka, and Delhi. He has been practicing in 16 districts of Karnataka and has been elected as a member of the Karnataka State Bar Council. His notable cases including assisting Senior Counsel Natarajan in the Supreme Court as defense counsel in the case related to the assassination of late Prime Minister Rajiv Gandhi, assisting in the urea scam case against former Prime Minister Narsim Rao and others, and successfully representing a Turkish company in the urea scam case leading to their discharge. He was also appointed as special public prosecutor in the acid attack case against wife and daughter-in-law of former Prime Minister Sri H.D. Deve Gowda, resulting in the conviction of the accused. Shankarappa has conducted over 1,500 cases in criminal trials across India and has oriented younger members in 171 Bar Association in Karnataka State. He has also conducted classes for doctors on medico-legal cases in Bengaluru Rural District and attended the Advocates World Conference in Cuba and Vietnam. In addition to his legal pursuits, Shankarappa is also committed to social causes. He is the chairman of Matru Education Trust, supporting disabled students and conducting schools for the mentally retarded, blind, and artisans in Bengaluru city. We are fortunate to have Shankarappa sir to share his insights and expertise with us today. His presence is a testament to his dedication to the pursuit of justice and his passion for sharing knowledge. Please join me in extending a warm welcome to Shankarappa sir and let us benefit from his wisdom and experience. Over to you, sir.
Thank you, madam. Thank you. Now, dear audience, madam, you want to talk to me in English or in Kannada? Both mix.
Mix ಮಾತಾಡ್ಬೋದು ಸರ್, ಎರಡು ಮಾತಾಡ್ಬೋದು.
ಯಾಕಂದ್ರೆ
ಮಾತಾಡ್ಬೋದು. Better it to be in English, sir, because the participants are from different parts of the country.
Yes.
Sir,
Yes. Welcome all the gatherings, friends. We are in India, and 1889, the first prior to the independence, British government have introduced the law IPC, Evidence Act, and CRPC. That is the foremost 1860 introduced Indian Penal Code. Thereafter, 1972 introduced Evidence Act. and thereafter 1898 introduced CRPC. See, after the 1898 introducing the CRPC, certain amendments have been carried till 1923 onwards. They carried several amendments in the CRPC. Finally, they have gave a CRPC to adapt in India on 1/4/1973. From 1/4/1973, though the CRPC containing section 1 to 484, 1 to 484, because earlier they used to, at previous old code, the trials used to be conducted in a magistrate court, or thereafter they have to, if there is a prima facie case is made out, they used to commit the case to the Honorable Sessions Court. Now thereafter, there is no bail as such, or no anticipatory bail as such. So 1973, after the introduction of this CRPC, they made it important 4 provisions for consideration of bail. One is a bailable offence under 436. The non-bailable offence under, you can approach anticipatory bail under 438. And if the person have been arrested, you can go for 439. And these are the material important aspects to liberty of citizen by applying Article 21 of the Constitution of India, because the earlier the Constitution was very silent with regard to liberty of citizen of this country. In 1978, the Lordships of Supreme Court, page 179, the Lordships of Supreme Court subsequently thereafter, even yesterday it appears in the newspaper, because 1981 715 Husaina Khatuna versus State of Bihar, there the Lordships of Supreme Court first time used the Article 21 of the Constitution, the delay of trial. The delay of trial, it berefts because the person who is a continuation in judicial custody, you are aware, in India, most of the criminal cases instituted against have-nots, because the most of people are illiterates and below poverty. Today, whatever maybe the institutions were run, the in the rural areas, the most of the litigants are below poverty line. They are the people approaching the honorable court, and we are conducting cases. But what is our education? Literacy in India is, even we did not reach 60%, except Kerala and other 1 or 2 states. But in India, majority or illiteracy still is going on. In this context, we are expecting that, yes, in 1923, after 1898 CRPC, after the independence, 1923, even prior to that independence, even 1923, they brought certain amendments by the British government. Even after the introduction of certain amendments, it is not useful for the litigant public at large. So therefore, after the independence of the India, then India thought that it is very required the liberty of the citizen, and the way they are conducting the trials, and innocent people unnecessarily languishing in custody. Therefore, 1/4/1973, the CRPC have been amended, they have been introduced. But till today, that is the Evidence Act 1872 or the IPC 1860, we have not made any changes. But now the present government, because introduced the 3 bills. Now, by introducing the 3 bills, you are aware, the under Indian Evidence Act, Indian Penal Code, and CRPC. CRPC, we are having section 1 to 484. The Indian Evidence Act 1 to 169. Then the IPC 1 to 511. Now IPC, they have reduced the introduction 1 to 514 sections, but there are certain important sections. 76 sections have been omitted, and 33 still they have no answer for the 33 sections. Now in CRPC, though they have introduced to 514 sections, the main important sections, which important aspect where the haves can have their say, the new act, because except the name, certain sections have been removed from CRPC. They made it introduce more sections, which is totally unwanted according to me. But there are certain sections now, because you know that most of the Indian people we don't have a literacy. We may be using a mobile. It does not mean that I know I am a literate person. But still we are having LTM people in India. In this situation, you have introduced the Bharatiya BNSS. You have introduced BNSS. Now, what are the material important sections? You have removed section 2 up to certain sections you have removed. You have made it the most important aspect is that complaint, contents of the complaint. Earlier code, section 154. Today, earlier there was 2D is the complaint, FIR, first information report. But you made it, you removed section 3 and section 2, you have introduced 1 to Z, A to Z. A to 1 subclass, A to Z, you have introduced. Now H is the complaint. According to the new CRPC, H is made it as a complaint. Now, prepare to the filing of a complaint in writing, or a person voluntarily appear before the station house officer. Now, station house officer also, you are again see the police manual, because a person at a relevant point of time who are discharging his official duty is being called as a station house officer. Now, according to the new amendment, the station house officer not less than sub-inspector, or next who is the hierarchy, next senior head constable, ASI can be a station house officer, not the police constable. Now, the section 2 subclass D made it to H, and also introduced A to subclass 1 to A to Z. You have to peruse the entire contents of the provision which have been introduced on BNSS. Now, how many people can understand the introduction of new sections? Now, according to the prosecution or the investigating agency, the main crux of the entire CRPC, when I observed the whole contents, I was expecting that there are some new changes will be there, because you are aware, a poor man cannot approach the Honorable Supreme Court or Honorable High Court in Karnataka. How many people are afford? But the entire new act have been introduced, BNSS, absolutely it was silent with regard to any person who have aggrieved any judgment rendered by the magistrate. He has to approach directly to the Honorable Sessions Court or the Honorable High Court. 3 stages. Now, you are also know that prior to accept summons case, in a warrant case under 239, now they have also amended under 239. Now, what is the powers of a magistrate? A magistrate has got a power under 239. He can peruse the entire material on record, whether he has got a prima facie to frame a charge, He's got his right. He did not file an application. But today, under 239 amended and 227 amended CRPC, now new act, they are insisting, unless you file an application, you cannot address the argument before framing up a charge. See, what is the right? See, it is a right of the accused. You are taken away by new act, BNSS. New act has been now taken away the right of an accused before framing up a charge under 239 in a warrant case, or under section 227 CRPC before framing a charge before district court. Now you are restraining is the liberty without filing an application. Because why you required to file an application? This is one of the important fact. Suppose I admitted certain aspects, I made certain aspects, but similarly, I am not entitled to file any alibi material. Suppose I am not at the station, I am somewhere. Even I got an electronic evidence to show that my CDR disclosed in a different place. But this aspect is silent. By the new Amendment Act, when you are asked to file an application for filing before framing up a charge, because you are aware, see, after 1/4/1973 amendment of new code, after the independence, the first case from India, ILR 1977, L. Munsami versus State of Karnataka, it is from my office, first case in India, approached the Honorable High Court because Supreme Court. Now, because it is a case starts from Bangalore, where the ITI chairman said to have been stabbed by the union people, they instituted a case of 13 against 13 people. This is the new code 1/4/1973, the first case where the Bangalore District Rural Court discharged 9 accused persons. Against that order, the state approached the Honorable High Court of Karnataka. The Karnataka High Court set aside the order passed by the Honorable Sessions Court. Against that order, the L. Munsami approached the Honorable Supreme Court. The Honorable Supreme Court upheld the judgment rendered by the Honorable Sessions Court. Thereafter, there is also an alibi, because in a case of alibi, you have entitled to produce at the time of trial. But today, the new amendment, it is silent. It is silent. Till my trial, I cannot say I am innocent. Once you say, till proving of guilty, you have to be treated as an innocent. That is the law laid down by the Lordships of Supreme Court, 1980-1622, Bachan Singh versus State of Maharashtra, Gurubakshan Singh versus State of Maharashtra, followed in 2011, page 3135 of the Lordships of Supreme Court. Even in a case of anticipatory bail, accused cannot hold guilt at the time of before trial. In view of this aspect, when you say that 65 has been amended, now 154 complaint need not be in writing. Even a maker, even an eyewitness can call the station house officer through his mobile, and such a material, if the station house officer, after receipt of the material, he has to make an entry in the SHD, and after the 4 days, within 4 days, see delay. You see, here is a case where even delay, because you are aware, ILR 1971, the Lordships of Supreme Court, page 501, Tulakalia versus State of Tamil Nadu, even the Lordships of Supreme Court holds that even a few hours delay, few hours of dispatching of delay, receiving of FIR delay, all these take considerations by the Lordships of Constitutional Bench as laid down a law. But here is a case where you amended BSN and we required. All right, you amended. Now, after the amendment, why you did not give a specific time factor? When you filed a complaint before the station house officer, or you are unable to come to the station, through mobile, you pass a message to the station house officer or to the control room. If such a message was being entered into the station house diary, that deemed to be a complaint, subject to within 4 days. See, within 4 days. See here. Why such a time? Fraction. Within a time, 4 days time has been provided in a person who can file a complaint under mobile on a call under the IT Act. It is admissible according to the CRPC now amendment. Now in this amendment, this delay, which goes to falsely implicate whichever has got animosity, he has got a time liberty to introduce a new color of the version through your media. And the station house officer might have been suppressed because the complainant want to implicate other than the accused persons who are really culprit, and you are given a time here because you are aware it is the first and foremost information you should be reached. At the same time, see, entire CRPC amended by the government, parliament or legislation, there is no specific investigation because under 157, now the amendment on CRPC 159, there is no specific argument whether there is a team, the kit, investigation kit. This kit could have been gave safe custody for really the unwanted people is going to be implicated, falsely implicated in the case. There is no argument nor silent on this aspect. You are aware, Justice Banurmat, while rendering a judgment in Karnataka High Court, he has very specifically directing the then government of Karnataka, you kindly constituted a kit. What is the kit? Kit contains the police officer, FSL officer, ballistic expert, handwriting expert, fingerprint expert, dog squad, all these people joined together and made it a kit. And today, if you give this opportunity, if the investigating agency under 159, then if they got an opportunity to implicate the innocent people, because the video or the mobile conversation or information reached to the station house officer, he was keeping quiet. He don't record or registered a case till the arrival of the maker who makes a call to the police station or who makes information to the control room, till you have to wait for his arrival. But the earliest code into 154, the telephonic message is admissible. It is deemed to be an FIR, subject to a maker can appear and the maker can question by the station house officer. If he admits, yes, I am the person who made a call and I informed to the station house officer, that is called a deemed FIR. But today, he did not register a case. He can wait the arrival of the maker who called the police station. He was to wait for that. This is silent on this aspect. Now, you are aware, in a 239, you can address the argument before the magistrate in a warrant case. See, after the argument, you are aware, the judicial magistrate of first class, he has no power to, he has got a power because 239, now 210, and also 227, these are the similar provisions One is exclusively tribal by the Court of Magistrate, and another is 227 exclusively tribal by the Court of Sessions. Now we are insisting you have to file an application. Now, yes, I will file an application before the magistrate. Now, what the magistrate will say is dismiss the application. Now, you have got a revisional power. Under 397, you are entitled to file a revision before the Honorable Sessions Court, because the right of the party, the right of the accused have been curtailed by the magistrate. In that situation, the revisional power could have been extended to the Honorable Sessions Court. But this is silent in New Act. BNSS, it is verbatim. Nothing has been changed except either IPC or Evidence Act or CRPC, except the heads and curtail certain sections. Your whole thing has been silent. See, these revisional powers, if really when the Honorable Supreme Court having a slogan, justice will be reached to the litigant public house. When the judgment rendered by the Honorable Supreme Court in India, justice should reach to the litigant public. When you say that, then under 239 as a magistrate, have-nots will approach the Honorable Magistrate Court. A small offences or even 302, only have-nots will commit, haves never come to the court. Whatever may be the judiciary today, majority have-nots approaching the Honorable Court. See, when you say that we are reaching justice to the litigant public, why you did not give a powers for the revisional court in a taluk level? Now you got additional sessions court in all taluks in Karnataka, and district you got a revisional courts. But 397 and 401, you did not give a power in one new act, BSNN. It is silent. It is silent. See, this is the most important area where the courts, the legislation could have been thought about the have-nots who are the sufferers. For a small issues, they are coming to the court. You want to protect their right, to protect their liberty, because now you got, if any conviction rendered by the Honorable Sessions Court, now we have to come to the only High Court in Karnataka, one court. And none of these southern people, which we have observed, we have also made a memorandum to the Honorable Chief Justice of India to have a bench at southern states. We are shouting. Till today, we have seen 4 Chief Justices of India from Karnataka state alone. None of them at least make an attempt, make a suggestion to have a bench in southern states of India. No. Similarly, when you say that justice go to the doorsteps of a litigant public, is there any possibility of have-nots to approach this Honorable Supreme Court? If he lost cases in Karnataka High Court, he has no power. Though he has got a manpower, but he don't have a financial power. Economically weaker sections, they have no right to approach the Honorable Supreme Court. So therefore, even these are areas where a single judge who disposes the criminal appeal, you could have given a chance for appeal, second appeal in the Honorable High Court, because in a case of writ under 226 of the Constitution of India, a writ petition dismissed, you got an opportunity to file a writ appeal before the Honorable 2 judges. Similarly, a single judge judgment in a conviction less than 10 years, you again create an opportunity for a litigant to file a second appeal before the very same High Court. He has not he cannot approach the Honorable Supreme Court once he lost the case in before the Honorable Single Court. So that could have been provided a provision in BNSS. No such provision has been provided. So these are the areas where important areas. The another aspect now, during the course of process of investigation under 159, now the act is silent on the basis of investigating officer during the course of investigation. Now you are aware under 173, 193 new codes. Now the statements of witnesses you are going to record. Now in a old code 161 subclass 3. Similarly here, after recording the 161 statements, you have also introduced as regard to the case diary under 172. Now case diary, what is the case diary? The BNSS is silent during the course of investigation. Any statements of witnesses recorded by the investigating officer, it shall be reported forthwith to the inquiry officer. Who is the inquiry officer? A judicial magistrate who was supervising the investigation. In that situation, it is necessary, it is duty of the investigating officer, if you don't want to tamper, or you don't want to introduce a color version, or you don't want to introduce those accused who are innocent, to restrict this innocent of people unnecessarily implicating in a rural mass, the only criteria this act could have been introduced after recording the 161 statements of witnesses during the course of investigation, he could have been submitted to the Honorable Jurisdictional Magistrate forthwith. Here, no forthwith, and this aspect is silent under 180, because under the BSNN 180 you can record the statement. The another important aspect, I don't know how this the legislators, without looking into the opening their eyes, now during the course of investigation recorded under 164 statements, that is 183 the BNSS. Now 183 for all these years, for 1/4/1973 till 2024, before July 31st July 2024, all the 164 statements shall be recorded by the judicial magistrate first class. Sir, today kindly see, open your eyes. Section 183 of BNSS, a district magistrate has been given a power to record 164 statements. Imagine. He has got any time. He knows about the legal aspects. How this investigating officer, it is a 164, now new code 183, it can be manipulated by the investigating officer by his whims and fancies. See, this is very dangerous. This could not have been provided, that it is the only judicial magistrate can got, because you are aware, under the POCSO case, you know, innocent people is going to be implicated. They're all guilty people. I know that. They're all guilty people. They should be punished. No exception to those people. But at the same way, it is the persons, in my experience, I have come across how this misuse this POCSO case under 164, recording 164 statements. Finally, they will get it compromised. But at the same time, when a daughter filed a complaint against a father, and in such situation, her statement was being recorded by the judicial magistrate. Now today 183 CRPC or BNSS. Now we have given a power to the judicial magistrate, that is a district magistrate, can record 164 or 183. Is it permissible? Is it going to helpful to the any litigant public? Are you going to protect the interest of a litigant public? A innocent people, he who has got a house, you are seeing today, yesterday, a doctor who studying MD in a campus in a Calcutta, the another doctor committed an offense against her, sexual assault on the doctor. See, in that situation, he can manipulate the district magistrate. I know that. You are also aware. An executive magistrate, you are allowed to empower to record 183 statement of the victim. What is the safeguards you have been provided? It is the collusion between the investigating officer and the DC or district magistrate. You want to eliminate any person who is a culprit. You want to expel from him the crime. The investigating officer and district magistrate can easily maneuver, can eliminate under 164 statement or 183 statement of a victim. So my request to the honorable gatherings or audiences, we have to protect this 183 should be amended. It should be recorded only by judicial magistrate. Other than DC cannot be empowered to record. In case of DC, he can empower to Taluka Executive Magistrate, provided it has been provided. 183. See, kindly see. What justice you are going to get? What is the justice to the victims? What is the justice to the injured? See, these are the areas where the legislators did not open their eyes. You have given a power to him. Of course, the another important aspect, now you have provided after the amendment of 65B, now you have been amended at 62, 63. Now under the amended, video recording, audio recording, you have been permitted to record all the evidences. Suppose you are aware the literacy of an Indians, because at a spur of moment they quarrel certain aspects, a land disputes, sharing of tap water abruptly or with a grave and sudden provocation. If the people quarrel with each other, in such a quarrel, if somebody get it hurt, or somebody hit with a fist, he succumbed subsequently. In that situation, if you record video or audio, tomorrow, even the kith and kin cannot get compromise of the matter, because the video recording and audio recording, it is under 160, under 63 of the Evidence Act 65B, Old Code. Now that contents of the document, you can't overbuy it. See, there you could have given some provision. In any such cases, you should have been some amendment to that aspect. You are keeping silent. You have seen only with a stern actions so those people, but at the same time, you have to see the situation. What made them to quarrel with them? What made them to assault them? And that aspect also could have been seen. I don't give exception in POXO case. POXO below minor, no exemption to those people who committed an act. But at the same time, I have come across the cases where daughter and mother joined together with the intent to grab the property from father. Now mother instigated the daughter file a POXO case against a father. It is a practically which I have seen. I refuse to give a complaint. See, these are the practically you have to think over. In that situation, what is the act to be in such situation? What is the remedy? Because see, after they got compromised, now father and mother and daughter are now together, happily living together. See, these are some exceptions could have been provided of these acts, though this is silent on this act, BSN silent on it. Now, the another certain important aspects that have been introduced. It is good because you have given once the accused have been arrested, you are aware, Section 27 of the Evidence Act, once you have been arrested, you have to intimate the kith and kin of the accused. Agreed. If suppose, if the kith and kin did not serve a notice and arrested, produced before the magistrate, he is remanded to judicial custody or a police custody, what will be the safety of the accused? No notice, no intimation. He has sent to his friend or his relative or no information. Suppose the investigating officer did not inform, then what is the remedy? Now, your voluntary statement. See, voluntary statement of discovery of fact is admissible now because Section 22 of the Evidence Act, new amendment, you have carried 22, Section 22 of the Evidence Act. Now, after you have been arrested, suppose you did not inform or you did not obtain the signature of inmates of the accused, what will be the effect of recovery? What will be the effect of voluntary statement? Now, you know that during the course of investigation, a voluntary statement is going to be recorded. Now, Section 22 voluntary statement, which is going to discover a fact. Now, suppose that voluntary statement, which is this, where is the safe custody of voluntary statement? The investigating officer did not produce the voluntary statement before the station house, before the magistrate within 24 hours, excluding conveyance. He don't produce it. He will file along with the charge sheet. In that situation, the act is silent. See, this is the most important. Voluntary statement of an accused leading to discovery fact. At the same time, you can also record a video and audio, and thereafter you are silent. What is the statement? What is the video? When it is going to be produced? You are aware in the old code, under Section 102, after recording the voluntary statement of an accused, any recovery is made at the instance of an accused, forthwith report to the judicial magistrate first class, who is a supervising authority. If suppose you did not produce, nor inform to the investigator, to the honorable court, now what is the effect of non-performance of the investigating agency? That there also your act is silent. Silent. So therefore, you are permitting the district magistrate to record 183. Really has who is going to evade the all criminal law or any allegations against him, he can escape from 183 from recording DC, district magistrate or a taluka executive magistrate. This is no provision or explanation of the new act. This is very important. Kindly see, this is very important. Now, recovery. Now, after the recovery, because you are insisting under the investigation under 159 that the investigating officer very specifically you have stated that investigation, all these investigations, You are going to produce before the magistrate. Now, your recorded video and audio, both were there within your hand. Now, suppose if the audio and video did not brought to the knowledge of the Honorable Judicial Magistrate, who is a supervising inquiry officer, and in a later words, you manipulate that audio video and produce before the magistrate and relying by the prosecution on 193. Now, kindly see this aspect. There should have been some restriction. Suppose he did not do that. Whether we can rely on such an evidence or we can discard his evidence, this is being silent in the act. This is most important. So in a similar way, now we also introduce arrest under 167, and now 167. Now you also amended the act by introducing the 167. That is after the production of an accused. Similarly, you have given a power to the magistrate to remand him not more than 15 days. 15 days. Sir, this is earlier there is also there. You might have been seen in the Kerala High Court. Kerala High Court, they have got even it is all the discretion of the powers of the judicial magistrate, who is under the supervising inquiry officer. If is required for further investigation, he can remand to police. He can remand to police if they ask for investigation. Otherwise, he can remand to the cause. Getting them back for 15 days is now become mandatory. Earlier, there is no mandatory as such. Suppose, agree, you have amended, very good. But at the same time, if suppose he did not produce within 15 days, you have given a time for 15 days, he did not produce, then it amounts to illegal custody. See, illegal custody, or having given a power to the magistrate to extend his custody in the absence of his production before the honorable court. No such. It is silent on this aspect. Now suppose he has not been produced, not been secured, R2 video or VC, he has not been produced. Then the non-production of an accused, you are aware that without his production you cannot extend his remand to the custody, judicial custody. But suppose he has not been produced, or no such remand application filed by the investigating officer, whether the magistrate has got power, automatically can extend his remand to judicial custody. That is silent on this aspect. Silent. See that. Therefore, you should have a cut figure to very. He shall not. Suppose he did not remand secure the presence of an accused. He has no power to the absence of an accused. Remand the accused. So he shall be produced because 167 subclass 1, subclass 2 Cr.P.C in a old code. Now you have also given a period. Now in a rape case, now you have acted 75, 76, 77, 70 in a sexual assault case. Within 4 months, you have to commence the trial, or you have to complete an investigation. This is, see, that you have given a power, agreed. Time limitation you have given for conclusion of the trial. Conclusion of the trial. But practically, you should also assume what is the ratio of judicial officers we have appointed here. In India, America, you got 10,000 people, you got one judicial officer. In India, for 1 crore, you got one judicial officer. On the basis of ratio, So you have to think of, you are fixing a figure. Within 4 months, you have to dispose from the taking of cognizance. You have also introduced POXO case. From taking of cognizance, within 30 days, you have to record the victim statement. Is it possible? Practically, you have to think over. When you say you are using Article 21 of the Constitution of India, liberty is utmost important of citizen of this country. When you go to the liberty, or the similar way, if the person is innocent, if he has been acquitted for the false investigation, what is the remedy for acquittal? Are you going to, is there any tortious liability on the basis of investigating officer of his faulty investigation? He is scot free. And even if they are guilty, the victim is suffered from injury, suffered from act. If he is subsequently died, what will be the compensation? If suppose you are going to get an acquittal, now you are giving a state is to be compensated. But the false case filed by the investigating officer, false case instituted by the investigating officer, what is the tortious liability on such an officer? See, this also should be, this is another important, where in American jurisprudence, if the false, see, subordinate appreciation, a lower court gave a false inconsistency of judgment of acquittal or conviction. Against such judge, you can institute a case in America. But here, even without material, you are a basis of an investigating officer. If you are going to convict without a consistency of the material, whose responsibility? Who is languishing in custody for several years? Now, the faulty investigating officer, he will cut free. Now, the accused is languishing in incarceration of the jail. Who is going to compensate for his innocence? See, this also, the act is silent legislation, absolutely nothing to that effect in the legislation. So, in this view of background, now the 482, now for all these years, now we are filing quashing of proceedings on 482. Now introduce a new act. After introducing new act, now you also introduce under the new act quashing of proceedings. Now suppose during the course of investigation, if the charge sheet has been filed under 193 or cognizance under 210, see, after the taking cognizance, if there is no sufficient material, he has to rush back for quashing to the Honorable High Court. Why? You could have given a powers, a revisional powers to the Honorable Sessions Court. At least you can save the lot of money, time of the litigant public. He has to go to pillar to the post, run from rural to Bangalore city for 482. How much amount he has to spend? How much time he has to spend? At least to restrict this, a powers under 397 or 401, the powers could have been given to the Honorable Sessions Court. We are seeing today 40 to 50% of Honorable Sessions Court has elevated to the Honorable High Court. Now they are sitting on under 482. They are discharging their services or quashing the proceeding. Similarly, why you undermine the Honorable Sessions Courts? Give the powers, all those powers to the Honorable Sessions Court. At least lot of time. This is one aspect, and lot of economically backward people are coming to the courts. They can save their time, they can save their money, they can happily, they have still got the confidence of the judiciary. In this situation, when you say that justice to the litigant public, why you did not occur to your mind while legislation has been passed or the bill was been passed? So this is most at the relevant requirement of this new act, certain important aspects where you have to make an amendment and give the powers, legal powers of the honorable district courts. The another important factor you have given, Taluka Executive Magistrate. Now, Taluka Executive Magistrate, he has got power to detain the accused 7 days. 7 days. 107. 110 proceedings. If he produced before the Taluka Executive Magistrate, he is empowered to extend the custody of such a person for 7 days. See, why legal? See, is all quasi-judicial proceedings. Quasi-judicial proceedings, you are aware how they are going to deal such matters. In that aspect also, when he has been empowered, see, powers to be enumerated under the act, your act is silent. When and what stage, what is the reason so to extend 7 years, that is also most important aspect to be dealt by the act, by the legislation. The another important, now identification of parade. Now section 9 of the Evidence Act, now you are holding a test identification parade. But today, you amended the act, now you are holding, a police officer can hold a test identification parade in the police station, that also can be accepted. Kindly see, you are know a mother who brought the child. Even if the child committed an act, mother never accept that my son is committed or my child is committed any offense. In that background, the investigating officer is the father of the child. He want to build by hook or crook how to implicate the innocent people, how to eliminate guilty people in this background, because my 44 years of experience exclusively on criminal trials, in a criminal trials, because you are aware, the Honorable former Prime Minister Rajiv Gandhi, who assassinated, now 22 people from death sentence to got an acquittal in the Supreme Court. What is the remedy of those people underwent for 2 to 3 years in the jail? Who is going to compensate? See, these in such type of cases, the act could have been something. Think over of it. Some amendments could have been carried in at least further. So these are the areas where absolutely, except changing the name of BNSS or BNS or BSA, except this, most of the sections retain. And even still, even today, 377 IPC, it is still silent. Silent. You are also defined section 399, 299, 300, 301, 302, 303, 304. Yeah. Now today, the CRPC or an IPC, a driver who driven a vehicle, if he committed an offense, you know most of the drivers, 99.9 are illiterates. And they are all economically backward. For their hungry, they used to go for job. when a word has been used accident, you cannot carry section 35, new IPC, amended IPC 34 to 35. Now 35, 3 subclass 5. Now under the 3 subclass 5, when a driver driven in the vehicle, now you attributed after the committing an offense, immediately you should go and inform to the police. This is one point. The second aspect, suppose, yes, he intimated to the police, he took the injured to the hospital, then what is the remedy? Are you going to exempt a criminal case proceedings against him? The act is silent. Now suppose he did not go to take the injured to the hospital, not intimate to the police, now you are going to extend that up to 10 years. What is the remedy? What is the livelihood? Most of the people who are choosing to come as a driver, who is an illiterate, who is economically backward, and have-nots. See, these areas, you should also concentrate how you can be convicted for 5 years. This also, there is no exception. When you are going to exception. See, these are the areas where the BNSS is completely silent, and still there are several amendments are required. My submission to the authorities, kindly, because the legislator could have been asked the practically advocates who are practicing or conducting trials, how this is going to be amended. You brought the new code, all right. But except changing the head, you could have been retained. See, the old codes, see, you are seeing 439. Now 439 CRPC. Now you have introduced the new Act 482. Now under 482, yesterday, day before yesterday, the Lordships of Supreme Court, Honorable Justice Gavi and another companion Lordships, dealt a law, 1 year, 6 months, Sisodi of Delhi, minister was in incarceration of jail. The Lordships of Supreme Court holds that delay of trial. Now delay of trial, Article 21 of the Constitution of India, followed in 1981 Husaina Khatuna versus State of Bihar, and 1987 ILR 1987 Patna, the Constitution Bench, and even the Lordships of Honorable High Court in 1994 Criminal Law Journal, that the Jharkhali, that is Eagle Mestri versus State of Nidsusi. See, these are the areas where the delay of trial. Once you say speedy trial, at the same time, the ratio also you don't think. The machinery, infrastructure also you don't think. Before amendment, bill you brought, yes, very good, we'll welcome. But at the same time, you should also think of this background. Without that, practically, without the ratio of judicial officers, or equipment, or infrastructure, or literacy, all these things to be think over before the act has been implemented. Now, because you brought the bill, agree? The bill, you passed 3 bills without a discussion in the parliament or giving an opportunity for the opposition. You brought the 3 bills. Now you also is been gazette notified, and from 1/7/2024 you are implemented. Now kindly see all the bills, any bill, it should be discussed among the affected public. You to discuss with the public. They are the people who are facing the problem. Without their knowledge, Practically, you have to think over, go to the mass and discuss such an act is going to be implemented. What is the opinion? These are things, areas where the new acts are not silent of this aspect. Therefore, it's my submission to the August body that the amendments which have been except changing numbers, IPC reducing 76 and 33, no answer. And Evidence Act, you introduce another two sections. You make it subclass so and so 179. You introduce. Now IPC 514 from 511. You have removed. See all this. I think World Act. See my submission that instead of bringing as act, you could have changed the nomenclature of IPC, Evidence Act and CRPC. That could have been prevailed, could have been extended, could have been in a safe manner, that could have been brought. But I don't know what is the legislators thinking by bringing. You see the IPC, different, you don't have a, at a time you can't get the sections immediately. You have to go search, where is this 65, where is 70, where is 121, where is 33 subclass 5. See, these are the way they have been dealt by the IPC. So hence, madam, hello?
Sir.
Yes, sir.
Madam, now any questions? I think
You can continue for a few more minutes, sir.
yes. Now, see, the trial, now under the trial, because you are aware, after the commencement of the trial, now the entire CRPC, you have defined only judicial magistrate, executive magistrate. Now, you are giving a power to the district magistrate. District magistrates. My humble request, authorities, legislative authorities who brought this bill, kindly open your eyes. We are requesting as advocate fraternity. We are seeing day in, day out. You are aware that powers vested to district magistrate to record under 183 will not get justice to the litigant public. Have-nots will not get justice. Most of the POCSO case, because under the POCSO Act, the entire material based on 164 or 183. And you have, of course, you have given a powers to the doctors, any victim, then approach even a private clinic doctor. He cannot refuse to treat the patient. That is very welcome. At the same time, you are having CWC. CWC you got under POCSO case. But you have given the powers under 75, 65, 66, 70 in a sexual assault on a woman above 18 years. It shall be recorded by only women police station agreed. That is good. That is good. We are welcoming. At the same time, suppose if that is not been done, if suppose any men police recorded such a statement, what is the remedy? Whether we can relay such statement or we have to reject in total.
80 ಆಯ್ತಾ 10th ಓಲು 80 ಅಲ್ಲಿ ಇದೆ 10th ತೋಲು ಅದೇ ಸ್ಯಾಂಡೇ ಹೊಡಿತಾರ ಸ್ಯಾಂಡು ಲಾಭ ಕನ್ಸಿಸ್ಟೆನ್ಸಿ ಇಲ್ಲ
ಹಲೋ ಇದಾದ ಸ್ಯಾಂಡ್ ಹೊಡಿತಾವ್ರೆ ಹಲೋ
Participants, please mute your mic.
ಯಾರೋ ಮಣ್ಣು ಹೊಡಿತಾವ್ರೆ ಮೇಡಮ್ see this 183 when I am shocked to read the entire contents of subclass 11 of 183 giving a powers to the district magistrate in case if he is busy he can execute executive magistrate, Taluka executive magistrate. See, the mockery of the act which has been introduced, we should not permit the district magistrate to record under 183. So, you have also given a direction. The investigating officer forthwith record 183 of the victim agreed. At the same time, you have to put a safeguard. There are innocent people, there are guilty people. Let the guilty will be punished. We have no we have no liberty, or we don't extend any such liberty for him, exemption for him. At the same time, you should also protect the innocent people implicated in such under the act by introducing a color version in the 164, whether it is inadmissible at the initial stage. How can we make use of such a statement? You log in 448 for a cross-examination. You can make use, because mere 164 statement, it cannot be admissible. It can be make use for contradicting the witness under 145 of the Old Act. That is there. But in the same way, how to protect this 164 statement? Because till the completion of 193 investigation under 173 subclass 2, 3, 4, 5, we are not entitled, accused is not entitled to 164 statement. Now, when it is going to be aware, see, you are aware, he has to move for bail application, accused who is in custody, he has to move for bail application. I have seen several cases in 164 statements. Most of the 161 statements who are freely allowed to go before the magistrate and recorded by the magistrate, there will be truth. There will be truth. At least 90% there will be a truth. But remaining 10%, 10% there will be a truth. And 90% will contradict their contents of the complaint, or their 161. So 3 statements will totally contradict. So in this background, you have to protect. You should give a protection. How this 164 will not tamper by DC? DC, how can you allow a district magistrate? You know, he is an executive officer of whole district. Where is the time for him? He is unaware of these things. In such a situation, you are giving a power to the district magistrate to record on 183 what is the justice will be get to the litigant public or the victim. These areas is completely silent on the act which have been introduced by the BNSS. So further, you should lay a raid on this. After recording such a statement, you should be forthwith release the copies to the accused, because once you say liberty, when you say 44A, he has to give all the material and he should easily access to the material. Once you say that aspect, if they curtail the 164, 183 statements, only he has to wait for till 193 completion of investigation. So what will the justice you are going to render to the innocent people? Innocent people. You also to protect them, because there is no tortious liability in India. In that situation, kindly see how you are going to protect the innocent people. That also your act is silent. And if the false implication by the investigating officer, how he is going to be dealt? He will be caught free. Accused will be languishing 10 years. He will get an acquittal. By giving a wrong judgment, how you are going to compensate? See, under the circumstantial evidence, section 3, see, for all these years, one is criminal trial, direct evidence, Eyewitness. If there is no eyewitness, circumstantial evidence. Now, under the circumstantial evidence, place of occurrence, bloodstains at the scene of offense, eyewitness at the scene of offense, article seized at the scene of offense, unknown identification of an accused, recovery of property, identification of property, fingerprints expert, fingerprint developed at the scene of offense. See, these are all things where, and ballistics, in a ballistic shootout cases, see, all these areas you have to protect. One is the interest of the victim, similarly the interest of the innocent people also. See, these areas you are not been aware, not been laid down a law, nor restricted or the duty of the investigating officer, failed to do performance of his investigation, what will be the effect of investigation? That is completely silent. Saka madam?
Okay, sir.
Yes.
Till 6:30 we have time. If you want to say something else, if you want to continue, you can, or else we will go for questions.
Now, see, 65B is been amended. Now, 65, now 63. 63 now has been made. Now, 63, you are aware the hard disk and mobile card, SIM card, memory card, and the hard disk, those companies, either Airtel, Idea, BSNL, or etc., etc. See, these are the companies where the government do not have a power to control these officers or the documents in their position. Now, how? Is there any guidance? All this because now you are more concerned entire investigation on video and audio and mobile. From mobile. See, these are the areas where any innocent person can also falsely implicated, or they can eliminate a guilty person. So in this situation, what is the role of an investigating authority? What is the role of the government? Is there any guidelines provided under CRPC in any such CDRs, you want to obtain from CDRs, from hard disk of these Airtels, BSNL, audio, unless there is a guidelines should be mentioned or should have been drawn in the CRPC, your BNSS. No such guidelines. At the same time, you say that any information forwarded from his mobile to the station house officer, it is a deemed complaint. Now, deemed complaint. How this will go? This information from my mobile, if I am using a Airtel, it will go first to the Airtel and go to the hard disk, store at hard disk. Now, hard disk, you are going to copy when? Who is the custodian? If they have this powerful person, he can manipulate the hard disk. Unless you instruction or a guidelines to those media, you cannot control, you cannot have access, they can easily manipulate. So therefore, the government under the CRPC, under BNSS, you should give a guidelines. When you say all this media is admissible and it is comes under the CDR and your memory card, your location, agree, very good. At the same time, you also give a protection to protect all these instruments. Unless the government have got a control over these, a private person can easily manipulate by the house. Srimantro, or yen bekadru madabodu. We are seeing what is going on. Even yesterday paper, today paper, I don't want to say about that. But this is going to be happen. House will give, they will go at any length to have their favor of evidence. So in this situation, you have said that yes, 63 it is admissible. Yes, admissible. The time factor you have fixed is within 4 days. Why 4 days? When I am an aggrieved, immediately I go to the nearest police station. I may anywhere. You have the Lordships of Supreme Court laid down a law. Any victim aggrieved, he can go any police station other than even beyond his jurisdiction. It is the primary duty of the station house officer. First take the complaint, register a complaint, thereafter forward to the jurisdiction police station. The law has been laid down by the Lordships of Supreme Court. See, these are things where you are keeping silent on these aspects. Act is very silent. These you have to give protection. Unless give a protection, the real guilty person will cut free. And unnecessary innocent people is going to be implicated. So therefore, you are aware, even from AR 1982 Supreme Court, page 839, head note C, the Lordships of Supreme Court laid down a law. The earliest information furnished by the victim to the doctor, that is still prevail. See, these are things where you could have been at least take the consent of a practicing advocates. Their views could have been collected before the act have been brought. You did not approach anybody. Nobody aware of these things. See, these are the areas where, agree, the legislative got powers. Yes, you have to bring certain, instead of naming a different name, you could have been carried several amendments. You have brought several amendments under 350A, B, C, D. You also brought under 376. Even the victim statement could have been recorded by under 164. Similarly, you have constituted a CWC. When CWC, no, in a POXO case, no victim have been taken before CWC. But still, directly victim going to the magistrate, giving 183, 164 statement, old code. Now you are permitting to go to DC. You have to wait for DC at least not 8 days to 10 days to get decision. See, that is why legally he's not though he's a quasi-legally officer, where is the time for him? Tomorrow we will accuse the investigating officer. The district magistrate will not oblige the police officer. What is the second remedy? See, these are the areas where the act is very, very silent. Yes, madam?
Yes, sir.
Yes.
Thank you very much, sir. Thank you, sir, for your thought-provoking analysis
Yes.
on the intersection of CRPC and Bharatiya Nagarika Suraksha Sanhitha. Your presentation has sparked important questions and reflections on the future of our legal framework. We appreciate you for sharing your knowledge and inspiring us to think critically about these issues. With your permission, we will now proceed to address the queries posted in the chat box, sir. May I, sir?
Yes.
Srimati Kalpana ma'am says, thank you very much for explaining in detail the loopholes in BNSS. It's sure to help the practitioners of law. Perhaps the authorities can be alerted on these aspects. We urge you to take the lead, sir. My query is, will the provisions of BNSS help maintain public order better? Will the
No.
provisions of BNSS help to maintain public order better?
No, madam, because see, I will go, I have gone through the entire contents of the BNSS, except verbatim. Here and there they have brought it, but the same you can compare, because I had a compare of the all the provisions, except a few. Similarly, it has been there. There is no much changes, except the top nomenclature has been changed. Except this, majority, see, majority same has been repeated. There is no much changes in the entire provisions. We can go one after the another whole sections. You see one thing, unlawful assembly. You can also the unlawful assembly. Several decisions by the Lordships of Supreme Court. See, you cannot expect it a knowledge. Somebody have got a weapon. You have got to intend to do away the life of a person so and so. Unless I have got a knowledge that you are having a weapon. See, same similar, there is nothing has been changed. But one thing, lot of IPC sections, I am sorry to say, the Indian Penal Code, they went in depth in all provisions when it will go into attract. But now your BSN, absolutely nothing could have been brought out by removing section 76 sections, silent 33 sections, and reduced to 356. 511, madam, 511 sections. See, when a person promising to marry, see, you are promising to marry, you have committed a sexual assault on the victim. Subsequently, you disowned her. You did not get married. Now, with the aid of 511, he could have been convicted for 1/4 of the sentence. Now, today, you have removed 511, 356, 1 to 356. What is the fate of victim? Think over. See, these are the areas where it is not helpful, because easily man can escape. A assailant can easily escape. See, they define section 299, culpable amounts to murder. When? See, these are the areas where you have removed all sections. You made it, removing all sections, you made it only 356. 511 where we are. 356 sections you have reduced. You see the provisions. See, there is very clear, madam. I say one thing. 377. How you make out? Against whom? You are not been there. It is not been there. Not yet. You are keeping silent on these aspects. And 302. Now 302, 304 and 304A. Now 304A, when you make the trial, you are taking a defense. Now you are going to convict him. You are going to convict him. Think over. There are several people who are depending on his livelihood. You are taking the livelihood of those persons who are depending upon him by introducing this. How many people are come for driving as a driver? Now nobody is prepared to come forward. They are afraid of it. When they are afraid of it, how it is going to affect on the public at large. If there is no transportation, how you bring a ration from Chintamani to Bangalore? If there is no driver, how can you bring a ration? Or how can you transport a milk in Bangalore city door to door? So their services are very important. It is going to affect on the public at large. There should be some exception. It is not intentionally killed. Your word used as an accident. There should be some exceptions. See, these are things where sufferers are public. Yes?
Okay, sir. Thank you. Shri Jaikumar KS asks, sir, what is the primary purpose of introducing e-FIR registration under BNSS 24? What is the primary purpose?
See, the primary, when any such an offense have been taken place in a certain place, now the victim sustained an injury. He became unconsciousness. He is not been attended by any public there. A passerby, he don't want to go to police station. In that situation, he can immediately forward a message through his mobile to the control room, and immediately the station house officer of the jurisdiction police can immediately come and rescue and save the life of the injured. That may be the intention of legislation, and that is the reason they are introduced the telephonic message or mobile message or video, audio, all these things have been brought in. Of course, it is true, correct. But at the same time, you also should give exceptions. A man who is going to inform, if suppose he did not come to police station, what will be the fate of information he gives to the police station? According to you, 63, within 4 days he must come and give it to the report or give a statement to the police. If suppose he did not turn up, what will be the use of your audio, video, or your telephonic message to the police station? How you are going to rely? A unknown man, a passerby, just to save his life, he has just called him and he left there itself. Why should I then? See, what will be such information? The law set into motion, agree. That is the first information report. 173, yes, agree. But at the same time, the law set into motion, as soon as received a message, it should be mentioned in the station house diary by a station house officer. That is the first information report. The law set into motion. But unless a injured who is unable to come to police station, if suppose he's got a mobile, he can pass a message to the control room or near to the police station. That can be treated as an FIR, and after he was been cured or after he became consciousness, immediately the station house officer rushed to the hospital and confronted his message through his mobile. That amounts to an FIR.
Okay, sir. Thank you, sir. Participants, any more questions? You can unmute your mic and direct your queries to the speaker. Any queries about the topic of the session? Okay, I don't think anybody has any queries. Thank you, sir, for your patience and willingness to engage with our queries. I now request our Dr. Vijay A.N., Assistant Professor, Vivekananda College of Law, to propose the vote of thanks.
Thank you, madam. Good evening, one and all. Respected reserve persons of the day, Cr.P.C, Senior Advocate and Vice President, AILU National Committee, Sri M.R. Lakshmanohar sir, Chairman, Governing Council, Vivekananda College of Law, Bangalore, Dr. K.B. Kempekoda, Principal, Vivekananda College of Law, Bangalore, my dear colleagues and dear participants. Myself, Dr. Vijay A.N., Assistant Professor, Vivekananda College of Law, Bangalore. It gives me an immense pleasure to propose vote of thanks to the resource persons, participants, and my dear colleague. Firstly, I take this opportunity to thank Sri Shankarappa, Senior Advocate and Vice President, AILU National Committee. Sir has delivered a wonderful lecture on the topic of overhaul of CRPC 1973 with the Bharatiya Nagarika Suraksha Sanhitha Act 2023. Sir, it was a very informative and enriching session. Sir, I, on behalf of the Janata Education Society, Vivekananda College of Law, and on my own behalf, I extend my sincere thanks to you, sir.
Thank you, sir.
And also, I would like to thank Sri M.R. Lakshmi Manohar, sir, Chairman, Governing Council, Vivekananda College of Law, Bangalore, for his constant support and help to conduct this kind of programs in our institutions. And also, I express my deep sense of gratitude to our beloved Principal Dr. K.B. Kempagoda for his unconditional support to conduct these kind of programs in our institutions. And also, I express my special thanks to Srimati Nirmala P. Egde and White Rose of VCL and coordinator of this particular FDP. So, Madam has taken so much of pain to conduct this kind of program. So, I extend my sincere thanks to you, Madam. And also, I would like to express my sincere thanks to Dr. Bhuvaneshwari S. Kulaki, IQAC coordinator, Vivekananda College of Bangalore, for your support and encouragement. And also, I take this opportunity to thank my dear colleagues for your support and encouragement to conduct these kind of programs in our institutions. Last but not the least, I express my deep sense of gratitude to the dearest participants for your active participations and making today's session a grand success. Thank you, one and all. Thank you for the opportunity. Have a nice day. Thank you. Over to Nirmala Madam.
I want to tell something.
Yes, sir.
Yes, sir.
I was working as a second divisional clerk in the Vivekananda College, junior college. I am the forefront of getting recognized of that college. Then I resigned and come back.
That's so sweet of you to remember, sir. Thank you, sir. Thank you, Vijay sir, also for your heartfelt words. As we are near to the conclusion of today's session, I kindly request all participants to complete the feedback form posted in the chat box. Your input is invaluable to us. Please mark your calendars for tomorrow's session, which will feature Honorable Mr. Justice K.N. Panindra, Upalokayukta, and former Judge, High Court of Karnataka, discussing Bharatiya Saksha Adhiniyama with special reference to confession. We eagerly anticipate your active participation. Thank you, one and all.
Thank you.
Thank you, sir. Thank you so much, sir.